Hi everyone. Thank you for coming to our webinar today. I'm Benetta, a legal associate with our firm, Cheong LLC, and it's my pleasure to be the moderator for our webinar session today. So to start off, on behalf of our firm, Cheong LLC, I would like to extend our appreciation to each and every one of you for taking your time off to support our firm's webinar session today. So by way of introduction, we are a boutique IP law practice based in Singapore, and we currently operate an office in KL, Malaysia as well. So in terms of the services that we provide, we offer a comprehensive range of IP services, such as IP prosecution, enforcement work, and commercialization, as well as strategy work. And we are specialized in assisting our clients with managing their global IP portfolios, with a particular focus on the Southeast Asian and Indian subcontinent region. So our speaker for today is my dear colleague Lee Joo Wen, who is based in our Malaysia office currently. And Joo Wen is specialized especially in trademark work, and she handles a lot of trademark prosecution work. So she has assisted clients from a wide range of industries, and today she'll be sharing more on the NIS classification for goods and services, as well as its importance in the trademark application strategy of your business. So before we begin, do note that this is an interactive session. So Joo Wen will be having live polls along the way, and please feel free to participate in them. And so we're looking forward to see what answers that we will get from these polls. Before we begin the session proper, if you have any questions along the way, do ask them in the Q&A pop-up as shown in your screens below. So you can just ask them at any point during the seminar. And do note that we will be having a Q&A session after this seminar as well. So Joo Wen will be answering your questions along with our firm's directors, Kevin and Ka Liang. So please stay tuned to the end of the webinar if you want to have your questions answered. Yeah, so this is my colleague.
Hi, Benetta. Hi, Benetta.
Hi.
Hi, thanks for your kind introduction. Very good afternoon to everyone in attendance. My name is Joo Wen, and I'm an intellectual property executive with Cheong. And I would like to say a great thank you to each and every one of you for choosing to spend 1 hour of this day with us in our September webinar series titled NIS Classification, Is It Really Nice? In this episode, we endeavored to explore the NIS classification, as well as to discover the various complications one may encounter during a trademark application process, with particular attention to the NIS classification. I've prepared a sneak preview to the content of this webinar, and primarily I'll be speaking briefly on the significance of trademarks in the 21st century. Following through that will be an introduction to the NIS classification, where we will explore its origin and its application in the world of trademarks, its inadequacies, as well as picking the right class for your goods or services, including what not to do in an application. One frequently asked question that we encounter is, why are trademarks so important in today's world? A short answer to that would be the protection of investments and the security on the return of such investments. Imagine spending a significant amount of time and funds to design this catchy logo and brand name, only to have it used without proper licensing or authority or even knowledge from you. Effective communication tool. In today's world where we can communicate emotions through cute little tiny stickers, it is clear that one should never underestimate the power of visual communication. As human beings are visual creatures and interact best when presented with visuals, this biological trait should be harnessed to its maximum capacity to generate revenue for you whenever possible. In a single brand or logo, trademarks can convey intellectual and emotional attributes and messages about you, your company, and your company's reputations, products, or services. Trademarks make it easy for customers to find you. The marketplace is crowded and it's hard to distinguish your business from that of your competitors. Customers viewing a trademark will immediately know who they are dealing with, the reputation of your business, and are less likely to look for alternatives. Your brand could very well be the critical factor in driving a customer's purchase decision. Trademark effectively utilize the internet and social media. Your brand is the first thing customers enter into a search engine or social media platform when looking for your products or service. Higher traffic on a website or social media platform translates into higher rankings, bringing in more traffic, and that translates to customers and more brand recognition. Trademarks are valuable assets. Trademarks can appreciate in value over time. The more your business reputation grows, the more valuable your brand will be. Trademarks are property assets, similar to real estate. So that means that it can be bought, sold, licensed, or used as security interest to further grow your business. In this regard, trademarks provide value beyond your core business sometimes. Trademarks can make recruitment easier. Brands can inspire positive feeling in people's minds. As a result, employment opportunities will seem more attractive to candidates. Employee retention can be higher if employees have positive feelings for the brand and the products and services offered. Trademarks are a bargain to obtain. Trademarks protection are relatively cheap to obtain in relation to the period and scope of protection it provides. Last but not least, trademarks are forever. Your trademark will not expire as long as you obey procedural and legal requirements. Some of the most recognized brands in the United States today have been around for over 100 years. Automobile player Mercedes was first registered in the 1900s, whereas Pepsi-Cola was first registered in 1896. It has been almost 120 years since Levi Strauss passed away, but the brand lives on today, stronger than it had ever been in the life of the founder. Here is a simple outline of the trademark registry application process. Step 1, application. Once the applicant confirms the details of the application form may be lodged with the registry. Typically, the filing of an application can be done within 1 day by professionals. This is especially important for applicants who wishes to have the application lodged by a certain date. At the formalities examination, the registry reviews the application form and decides whether the application form and the supporting documents submitted are sufficient. The registry will issue a formalities refusal to instruct the applicant to comply with the formalities requirement if it is not. If the documents are in order, the application will pass on through to the substantive examination. The real examination of a trademark application begins at the substantive examination, and the NIS application as applied is examined in depth. This is where the mark is examined in accordance with national trademark laws, and also where the mark is examined against the register to determine if the mark in question is confusingly similar to other existing marks in terms of the presentation of the mark, as well as the goods and services claimed. If the registry is not satisfied with the substantive elements of the application, a provisional refusal may be issued, and the applicant will have the option of responding to the refusal or abandon this application. And an application that has satisfied the requirements of substantive examination will then move on to publication stage. Before a trademark application matures into a registration, the public has the opportunity to challenge a pending trademark application. When a mark is published for opposition, any member of the public who believes it may be compromised by the registration of the mark may file an opposition with the registry. A variety of electronic watch services are available for trademark owners seeking to monitor any marks that may be too close to their registered trademarks. During the opposition proceedings, both parties are given an opportunity to present their points before the registrar. If no opposition arises during the publication stage of the mark will finally obtain registration. This is the end of the application process. Once a trademark obtains registration, protection is valid for 10 years, and if the owner wishes to extend the length of protection, the owner merely needs to pay the requisite renewal fees and the mark will be renewed for another decade. The NIS classification was established as a result of the NIS agreement, a multilateral treaty administered by the World Intellectual Property Organization. The NIS classification is a system of classifying goods and services for the purpose of registering trademarks in its proper class. It is updated every 5 years since its first edition in 1963, and its latest 11th edition groups the goods and services into 45 classes and allows users seeking to trademark a good or service to choose from these classes as appropriate with ease. Since the system is recognized in numerous countries, this makes applying for trademarks internationally a more streamlined process. The classification system is specified by WIPO, and it simplifies the trademark process by ensuring that the goods and services covered by an application are classified in the same manner in all trademark offices adhering to the classification. The use of the NIS classification by national offices has the advantage that trademark applications are coordinated with a single reference point to the classification system. Filing is thereby greatly simplified, as the goods and services to which a given mark applies will be classified the same in all the countries that have adopted the system. The fact that the NIS classification exists in several languages also saves applicants a considerable amount of time and work when filing internationally. Approximately 150 trademark offices worldwide uses the classification, including the US Patent and Trademark Office, and this of course includes our home grounds, Malaysia and Singapore. As mentioned earlier, in the NIS classification, the goods and services are divided into 45 classes, each class covering a different category of goods or service. Classes 1 to 34 relates to goods, and classes 35 to 45 relates to services. In total, the NIS classification contains about 10,000 indications of goods and about 1,000 indications of services. It should be pointed out that the NIS classification is not arranged according to any particular order of business sector or industry, but rather it is categorized according to the nature and characteristic of the particular goods service. Each class of the NIS classification contains a class heading. The class heading are the official descriptive names of the classes. They generally describe the nature of the goods or service contained in a class in very broad terms. The explanatory note of any given class explains and further elaborates the reasoning if a particular goods or service fall within or out of any given class. The alphabetical list is the most detailed level of the classification. It indexes the individual goods or service in an alphabetical manner appropriate to each class. The general remarks explains what criteria should be applied in the event a term is not found in the alphabetical list and cannot be classified in accordance with the explanatory note. So as using the classification may be daunting to many people as there are several points to consider, we have prepared several examples which we believe may lend some insight to help understand the workings of the NIS classification. An example in class 2 includes mainly paints and colorants used in protection against corrosion. This may cause confusion for someone who may wish to claim inks for stationery purposes, as even though inks are also colorants, it may be rejected in a class 2 application as the more appropriate class for stationery inks is class 16. Notable marks in this category are Nippon and Dulux, known for their paints. Class 3 mainly includes toiletries and non-medicated cosmetics. This class also includes household cleaning products. A common mistake we see in new applications in class 3 is the inclusion of toiletries which are medicated in this class. An uninitiated applicant may believe that medicated shampoos will fall within this class along with shampoos, body gel, and other similar toiletry related items. This will likely face an objection by the registrar as class 3 is home to non-medicated goods and therefore medicated shampoos belong in class 5. In this class, we have familiar brands such as Nivea for their body creams and lotion, Dove famed for their hair care products, as well as Ajax for their household cleaning products. Tide and Downy are also in this class, famed for their laundry detergent products. Bosch and Honeywell are some of the leading marks in Class 7, which includes mainly machines and machine tools. An application in Class 7 to include motors, engines for land vehicles will likely face complication, as the purpose of the motor is to be included as part of the automotive vehicle. Therefore, the more appropriate class is Class 12. Class 12, as mentioned earlier, is a class dedicated for the protection of the automotive industry for vehicles by land, air, or water. In this class, we see marks such as Airbus, Aston Martin, and Proton, among others. Proton is a Malaysian automotive company, and it is the Bahasa Malaysia acronym for Perusahaan Otomobil Nasional, translated to mean the National Automobile Company in English. A children's toy proprietor may wish to register his tricycles in Class 28 rather than Class 12, as tricycles are more suitably classified as toys and not automotive per se. I think most of our audience has got this right, didn't they, Vanetta?
Yeah, it seems like it. You're right, Joo Wen.
Yes, thanks, Vanetta. Clothes and apparels. This class should be very familiar to everyone, ladies and gentlemen alike. A study conducted in Malaysia in 2019 reveals that Malaysians spend 771 million USD on fashion on the e-commerce platform alone. It is no wonder that Class 25 is one of the largest classes in the NIST classification, as it covers clothing, footwear, and headwear for human beings. Brands such as Zara, H&M, and Adidas need no further introduction, as they are multinational clothing retail giants. Even though fasteners such as zippers and ribbons play an integral part on the garment that they are affixed on, they, however, fall in a separate class altogether, even though they are related. Classes 29 through 35 refers to the fast-moving consumer goods section. Class 29 includes foodstuff of animal origin as well as vegetables, but excludes foodstuff for animals. Marks such as Bula, famed for their ice creams, and Bega for their cheeses belong right here in this class. And who can forget Ayam brand, a native Singaporean brand that is synonymous with pre-cooked canned food, such as sardines, tuna, and chicken curry. Even though raw cow's milk, which is a Class 29 item, is the basic product for making powdered milk and infant formula constitutes food for babies, and hence they belong in Class 5. Class 30 is home to many of our indulgences, home of chocolates, coffees, and teas. We see our comfort brands such as Leonidas, famed for their fine Belgian chocolates, Mars for their affordable chocolate treats, Starbucks coffee and Davidoff's for their coffees, and Lipton, famous for their wide range of teas. Even though most dietary supplements are plant-based, supplements are excluded from this class and are classified in Class 5. Marks such as Fanta, Coca-Cola, and Schweppes are classified together with beers such as Budweiser and Kilkenny in Class 32. Interestingly enough, the only alcoholic beverage found in Class 32 is beer. Beers have been in this class since the very first edition of the NIST classification in 1963. Subsequent proposals aimed at transferring beers from Class 32 to Class 33 to be with other alcoholic drinks have always been rejected by the NIST Committee of Experts. At the time the classification was established, beers were included in Class 32 because they were often commercialized by the same companies that produce and or sold soft drinks. Soft drinks were also considered an alternative to beers. Even though milkshakes are non-alcoholic beverage and seems prima facie accurate to be classified in Class 32, it is, however, more appropriately classified in Class 29, as milk is a product of animal origin. Thus far, we have discovered that the NIST classification is used in many countries, and as a direct and inevitable consequence, different thresholds of specification examination may arise due to subjectivity level of the examiners. For instance, in our course of work, we have encountered that specifications in Thailand and China are subjected to greater technicality and detail than in other jurisdictions. This will unsurprisingly give rise to complications, as this would mean Thai and Chinese applications may very well end up looking more detailed and unique than those found in other countries. In this age of globalization, it is no surprise that applicants may apply for trademarks in various jurisdictions all over the world. As such, another issue to consider is when the translations of the specifications are required from English to another language, Spanish, for instance, for an application in Spain, or vice versa. Inaccurate and imprecise translation may lead to vague, ambiguous, and confusing results, because such item may prima facie seem to be more properly suited to be in another class rather than the item that it was intended to be. The unfortunate result of such an issue would be the non-compliance of specification requirement of a particular local registry, which may in turn lead to specification objection. In a country such as China, the NIST classification is no doubt being used, but the local office has developed a subclass system to be applied in determining whether a goods or services are similar or otherwise. This subclass puts item under a figurative microscope and is then scrutinized to ensure that the item is properly classified. For example, in classes 7 and 25, there are 54 and 13 subclasses respectively that requires due consideration, in addition to that of the NIST classification when classifying an item of goods or service. As China is gaining popularity for trademark application, this local practice is important to be taken note of, as it also includes goods and services that are commonly used in China, but yet are not included in the NIST classification, such as hair mousse in class 3, mashed potato in class 29, and housekeeping service in class 45. This subclass system also creates a whole new challenge when applicants are trying to determine the right class and subclass for their goods or service, as goods or service in different subclasses are considered to be dissimilar, even though they belong to the same NIST classification. Therefore, for applications in China, it will mean that the applicant would need to cover as many subclasses as possible so that it obtains the greatest and widest scope of protection. Last point for discussion is that the acceptability of class heading. Class heading, as we have seen in the earlier slides, are the official descriptive names of the classes and generally describe in very broad terms the nature of the goods or service contained in each class. For instance, Michael, a restaurant chain owner, may already have registrations in Malaysia in class 35 in respect of its class heading specification, services rendered by advertising establishment. Over the years, Michael's business expanded exponentially and he now wishes to apply for a trademark in Israel for the same service claim in the Malaysian registration. Michael will be upset to learn that the Israeli registry is not in the practice of accepting the adoption of class heading as specifications proper, as the registry may deem it to be too general and too vague, and hence such application would require further refinement and specification. Michael should engage a local professional to further refine the specification such that it meets the local registry requirements and to tackle any issues that may arise subsequently. As a conclusion for the purpose of this webinar, I believe the members of the audience will agree with me that the NIST classification is therefore not as nice as the conceived idea and concepts. As with everything, there will always be room for improvements, And fingers crossed that these issues will be addressed, or at the very least be taken into consideration in the next edition of the NIS classification. I see Bernetta raising her hand, and I'm afraid to say that that's my cue that my time in this webinar is up. I would like to say a heartfelt thank you to all who attended in making this webinar a successful one. We hope this session has been informative and insightful for you. We have a Q&A session coming up, so please have your questions ready. Please be reminded to use the Q&A button so that we can pick up on your questions.
Hi everyone, so please feel free to ask your questions in the chat box at the bottom of your screen. So thank you, Joo Wen, for that very interesting presentation. So now maybe we'll start on the Q&A session. And I noticed that there are a lot of interesting questions that are being asked. So since Joo Wen is located in Malaysia, and our office in Malaysia, maybe we can start with a question that is closer to home. So Joo Wen, one of our attendees have asked, what is the time frame, which I think they're very curious in terms of opposing a trademark in Malaysia. So one of the attendees has asked, what is the time frame in which they can oppose a mark in Malaysia? Yeah, that's quite an interesting question. And I think Joo Wen will be quite well placed to answer this. Yeah. Oh, it seems like Joo Wen is facing some technical difficulties on her end. Maybe we'll start with Kevin and Kaliang. They're here to join us for the Q&A session. So Kevin, maybe you want to give some input on this first question. I think they, if I can repeat myself, they are interested in knowing the procedure and the time frame to oppose a trademark in Malaysia. Yeah, I understand there are a lot of concerns with this. So.
Yes, hi ladies and gentlemen, this is Kevin here. We hope you'll get Joo Wen back live with us. In the meantime, I'll take care of this question. The opposition period for Malaysian trademark application is a 2-month period from the time the Malaysian IP office publishes the trademark in its journal. So third parties can, raise their objection via an opposition filing during that period of time. And if they need more time to consider, there's an extension period possible as well, so long as they file it within that period. So that's pretty much the time period we're looking at for oppositions against Malaysian applications.
Okay, thank you, Kevin. That was quite, that's a good input and quite interesting one as well. So I think another member of our audience has asked, this one I find this question quite relevant because given how interconnected we are these days and the prevalence of social media. So the world is becoming smaller, but as we know that trademarks can be used on our websites and various social media, and they are currently used on social media as well, but at the same time, they are also territorial. So one of our audience has asked a very interesting question as to, in this case, since trademarks are known to be territorial, but they are also used in these sort of interconnected situations, which country would it be best to file the trademark in, since that, we are becoming more global with the prevalence of social media? So
it's a good question. There are various ways we could address this question. Perhaps I'll bring up some points that come first to mind, and perhaps if there are any other views from other panelists, or Joo Wen, when she comes back, she can take it from there. When it comes to use of your brands on the online marketplace, I think one thing to really consider when looking at trying to achieve, well, in a sense, the most effective is to still look at your important markets first. If you are marketing your products online, you should through looking at your marketing efforts and your sales, you'll be able to figure out from there where your sales are coming from the most. Especially also the other consideration will be you might actually be making your products available only to certain countries, because you have arrangements for shipments to certain locations as well. So it's where your products are going to be deliverable to, and also which markets are most valuable to you. based on, the results of your marketing online and where the revenue is coming from. So when you're first starting out, you may not know, exactly, where your best markets are. So I think it's a bit of also, trying to make certain business decisions and projections on, what you think your key markets are, and making an attempt to seek protection for those markets at an early stage. So it could be a tiered process of getting your registration, looking at what you think are your priority markets, and then seeing how your marketing efforts develop from there, and considering whether you need further protection. Yeah, especially for companies like SMEs that might be a bit tight on budget and might not be able to do one grand covering all the world kind of project for protection. Apart from that, I think that there are other angles for protection on the online space. It goes a bit out of the trademark realm, but still IP. If your brands that are used online are in the form of logos, then you might also be able to avail yourself of another field of protection in the IP space, which is copyright protection. So but you do have to make sure that you have your copyright, your rights to your artistic work in a logo properly secured, and that's something, I guess, a bit beyond the scope of this particular. Just something for everyone to think about. These are the two thoughts that I have.
Yeah, so that's very interesting. So Kaliang, do you have anything that you'd like to add in addition to what Kevin has already presented on? If not, I think Kaliang? I think maybe Kevin has summarized it pretty well. So that's a very interesting question, especially relevant to how to us these days, because we are very interconnected and trademarks are often used, but despite the fact that we are very global, trademark is still quite territorial. So yeah, I thought that was a very interesting question. Kaliang, do you have anything that you'd like to add? This is our firm's managing director, Kaliang, by the way. Yeah.
Hi everyone. Sorry, I have to admit, I was trying hard to figure out the connection problems we're having right now, and I wasn't a very good audience to Kevin's answer. But looking at the question about where to protect your trademark first, I think what I caught Kevin saying would be something I agree with. It's largely focusing on what are the countries of interest to you really, where do you want to market your product, where do you want to manufacture your product, because that's likely where your threats are likely to surface first. But I thought there was a related question earlier. If I might just pull up the list of questions. There was a mention about just hold on. Yeah, there was a question about trademarks being used on websites and social media. I believe there was an attempt to answer that earlier, largely due to just you have to take very good care that you don't infringe rights that way. But perhaps one thing that we might also want to pay attention to as well is to the fact that trademarks can come in many forms. You might have trademarks that are words, but trademarks that are logos as well. So they might be pictographic. Because they are pictographic in nature, there's another set of legal rights that might attach to them, which is copyright. And if these pictographic trademarks have copyright protection as artistic works, it is not a question just of whether you are using the trademark on the social media or web presence in relation to goods and services that the trademark has been registered against. Whether you are using a pictographic trademark that way, which already has copyright protection attached to it, just because you use it without permission of the copyright owner, not necessarily the trademark owner, that could potentially get you into trouble. So do be careful when you want to adopt pictures that you have no clearance to use. Of course, the best thing to do would always be to ask for permission. But we understand in commercial reality, sometimes it's not very easy to obtain the permission. As far as what we can suggest on this public platform is, well, you have to make your commercial call. Of course, if you encounter legal challenges as a result of that, you're talking to some people who can help you here. To the extent that we can help you, if you willingly and deliberately ignore the suggestions we've given you, there'll be some challenge, but we'll definitely want to help you out should you have that kind of problem.
Okay, thank you,
Just to follow from what Kaliang just said, just a bit of a reminder as well that it's a two-way thing. One might be, as a business owner, you might be thinking, oh, I'm going to apply for a trademark protection because I want to protect myself because I want to be able to stop other people from using my brand in various jurisdictions. That's using trademark protection registration as like a sword. You want to attack someone, but everyone must remember that in the very first place, the need for protection is to actually to protect yourself against someone who might be a competitor, or someone who might just be not happy about the presence of your brand or trademark. Usually it's a competitor, and well, sometimes it could be even rogue traders or cyber so-called trademark squatters, rather, the trademark equivalent of domain name squatters. And so you don't want to get into situations that, well, you really don't want to have to be, because you want to be focused on your business. And so with professional advice that should help you to support your way forward in your business with hopefully not so many, if no issues on the legal side for your IP. Yeah.
That's very interesting. Thank you, Kaliang and Kevin, for sharing some insight on this aspect, this global aspect of trademarks. And so another question I think everyone would be curious about, because in terms of a due diligence measure, when you want to assess like the registrability of a proposed trademark, or you want to see whether there were prior trademarks that are similar to that trademark that you want to register. So what do you suggest that people should do, and what databases are there available? And perhaps maybe you can suggest how we can how we can conduct a due diligence on when we want to register a trademark, or we intend to register a trademark. So I'm sure a lot of people are very curious about this, and perhaps Kevin, you can give some input on how they can go about doing this.
Okay, I'll start off. Just to get a confirmation that we're looking at due diligence before trademark protection. That's
I think it's like before you start filing the trademark application itself. So how can we conduct our own due diligence, or how can we engage other people to help us conduct this sort of due diligence?
Sure. Now there are obviously like two levels of this, or perhaps a combination of both. It could start from the business owner themselves. You have certain resources that might be actually quite readily available to you to do at least some preliminary researches to see if a brand that you are considering to use for your product or service might actually be already used by someone else, and you might be in danger of encroaching on someone else's space. So if you know it, then you might want to think of another brand. And so examples of some of these resources would be very simply your Google searches. Searching for a brand on Google search can give some at least some cursory extent of information that is at least available and on the internet for you to make some sort of gauge, at least on a a basic level. There might be other kinds of searches that might be available also online. The thing about some of these other searches that might be a bit more specific, specialist or focus on trademarks. They might be potentially a bit more advanced in terms of how you would need to make in order to get the best results and also to make sense of the results. So there are many such resources available apart from some countries where the searches for trademarks are still conducted manually. But for all these kinds of searches, in order to get the best results from them, it's probably a good idea to get someone professionally trained to give you a more in-depth and so-called intelligent kind of comments on the what are the results that you generate from such searches. And intelligent being not to say people who are laymen are not intelligent per se. Obviously they're not, but the intelligence is more in understanding how to make sense of what one trademark will be considered in relation to another in terms of similarity, how they might be seen as conflicting, and thereby how to what extent a competitor might have a stronger chance of successfully stopping you or so-called suing for infringement of a trademark.
Yeah, I think that's very important to conduct sort of like a review before you actually want to register your trademark in a certain country so that you know what trademark to register in the first place. And I think this would be the due diligence aspect prior to registering the trademark. But prior to filing the application. So what if, let's say, you want to oppose, let's say you want to ensure that third parties do not register the same mark after you have published the mark? Is there any way, maybe in terms of watch services available? I think maybe Joo Wen is back, so maybe Joo Wen can answer this question. Yeah, I hope your technical difficulties have been resolved, Joo Wen.
Yes, I hope so. So there is a question from the floor to ask how can I check if my product is already registered as a trademark in Singapore? Any portals to search on our own, etc. So firstly, we can run through a conflict search through the IPOS website, but this is rather complicated. So we do it as a service as well. And there is another question that I see. It is mentioned in the presentation that watch services are available. Does Ella Cheong LLC provide such services? Yes, the answer is we do provide watch service, and since there are databases that we can check on, and it is not as straightforward as we like them to be. We have conducted watch service for several of our clients as well, and if you would like to engage us to conduct your watch service, please feel free to drop in an email for us and we'll be able to assist you further.
Thanks, Joo Wen. Yeah, I think that was quite a good response. And so moving on to the next questions that we have. So I think in relation, maybe more relevant to what Joo Wen has presented earlier in relation to the needs classification and specification items in the trademark application. So there's one of our attendees have asked this question as to, let's say, how trademarks trademarks are so territorial. So every time you file an application, you would have to file a separate application in each country usually. So one of them have asked, let's say in a scenario where they received an office action for items in a specification for a trademark application. So would they have to change that? Let's say they received this office action in Singapore. Do they have to change the items of the specification for the same mark overseas? Or is it different across, like, are the specification requirements different in various countries? So perhaps Kaliang or Kevin would like to take this question. Yeah, so.
I'll leave it to Kevin.
Okay, I think Kevin is more well placed because he's been dealing with a lot of specification matters. So do we have to follow the same set of specification in every country, or are there different rules pertaining to each country?
Yeah, well, this is an interesting question. You know, the manner in which you would file your applications in various countries may also be dependent on the mode of filing that you might be adopting. As some of our audience might be aware, there are well, principally two modes of filing. The basic form of filing has been around for the longest time is domestic or national filing. So you file an application directly in the country of interest to you. Then over the past few decades at least, we've had another system come up which is called the international registration system, the Madrid system. And there are quite a number of applicants these days who are using this a bit more often, partly because it usually entails some cost savings. It could be quite significant, particularly at the outset of the application process, because of the fact that it's one application and you select all countries, and it's it's a more administratively convenient procedure, so and therefore the costs are less because of that. When you file, in your various countries as national filing applications, there's more flexibility when it comes to the scoping of your products or services in terms of what we call a specification for the filing, because you are not restricted to having one single form and having one version, generally speaking, one version of your specification of goods or services. So if you do it country by country, then it's possible to do a bit more customization right at the outset, to try as much as possible to have a specification that satisfies or should satisfy the examiners in the IP offices of those countries. Suffice to say, I think Joo Wen has addressed it in her presentation. We have the NIS classification. Some people might thought it's nice, but yeah, it's pronounced as NIS for the part of France. But she did. I mean, we have this thing about is it really nice? The public would have really thought they were really nice if the principles behind the NIS classification were applied identically or exactly in the same way in every country in the world. Now, unfortunately, that's not really the case when it comes down to the IP office level in each country, because of the different examination practices that are in place. We have different approaches that are taken. So a particular list of goods or services may be completely fine in a country like Singapore, for example. But if you apply the same specification in, let's say, the US, United States, there might be further specificity required in a country like the United States, where the US IP office, the USPTO, may ask for, say that certain items are too big, but that's in the context of the US. So that's how it is. We have to live with things as they are. The world is huge, and we have diversity, and as a result of diversity, we have different approaches being taken. So so that's in a sense the good side of doing national domestic filings. If you do a international registration, you are rather restricted in terms of doing much variation from one country to another within one international application. So you may have to deal with or address certain issues along the way, but usually these issues are not so difficult or insurmountable, provided your basic specification of goods or services that you use for the application is sound and at the very least in accordance with the NIS classification. then usually, dealing with local office objections is not an insurmountable task. Yeah, I hope I answered the question. Now I'm trying to recall what the question was, and I went on and on.
I think you've more or less answered that question. Yeah, this seminar is in relation to the needs classification, and I get what you're trying to say. So that's quite an interesting answer. And I think on a related note, because on hindsight we might not know what exact goods we want to register the trademarks for. So sometimes we might have left out like certain goods that perhaps we want to venture into in the long run. So one of the attendees has asked an interesting question, which is, can they add more goods after the trademark has been registered, or do they have to go through the same filing process over again for the new products under the same brand? So I thought this was quite relevant because we don't really know what type of goods we want to register for at the start of the whole registration process. And yeah, so maybe Kevin or Kaliang would like to give some input on this, or Joo Wen?
I think I can take that question.
Yes, Joo Wen.
If an application has already obtained registration, you are not allowed to add more goods to the specification. You can, however, remove certain items if you feel that it's no longer relevant to what you offer. But if you want to add more, then you will have to go through the application process all over again, because it would require substantive examination on the part of the registry.
Would it incur like certain costs, or is it usually, and is it quite normal?
You will incur the ordinary filing a new application cost.
Okay, and is it quite normal for people to remove specifications?
Yes.
In the applications?
It's quite often we see it.
Yeah, so I think another in relation to cutting down costs, like some people are very curious on, some of our attendees are quite curious on how we can, whether they are in terms of IP filings in different countries, maybe more so in relation to Singapore. So are there any grants available, or is there any incentives to allow people to file more applications? Perhaps in this note, Kaliang might want to take this question, since you have been quite quiet throughout the whole Q&A session. So perhaps you want to take this question. Yeah. Hi.
Sorry, Benetta, I was trying to look through the list of questions not answered yet, and I might not be scrolling to the correct question you were talking about. Which one were you referring to?
One of our attendees have mentioned that their company is currently cutting down the legal budget for this year. So I suppose they are, at the same time, they are interested in filing IP applications, trademark applications in Singapore. So, but cost is a very important factor when it comes to filing and registering your IP rights. So I suppose they're curious as to whether there are grants available, or?
If you're a Singapore company and you have been around for a while, you must have at least 30% Singaporean shareholdings. You might be able to tap on some of the grants given by Enterprise Singapore. They have two programs, one called the MRA, the other one called the GCP, which might help you cover up to 70% of your costs. So that's definitely something worth looking into. So for those of you who might not be Singaporeans listening in, well, that's the good thing about being in Singapore.
Yeah.
One way around it, of course, if you do have a presence in Singapore, you set up a Singapore company as a IP holding company, options like that might become available to you.
Yeah, I'm sure this is very important to us and to all the business owners out there whose first main concern might be with regards to costs of filing. So yeah, I'm sure we can, I hope they all manage to get some insight on the different grants available to you for IP registrations in Singapore. So
well, beyond grants, one of the mechanisms that some companies are starting to use is the international registration system. So under the international registration system, you can file an international application. And in that international application, you just select the countries of interest to you. You do not have to select all countries because with every country you select, the cost goes up quite significantly. But all in all, you probably will pay less than if you were to submit applications in the countries individually apart from the international application. So what some companies do is they tap on this international registration system by submitting an application that covers an initial list of countries, not all the countries, but just an initial list. And subsequently, as their business develops further and other countries become relevant, they will extend this international registration by a process known as a subsequent designation application. So you basically expand the scope of this registration by topping up the difference in the countries. There is still an additional processing fee that will be charged by the World Intellectual Property Organization, but you will still end up probably paying less than if you were to submit applications individually to those countries. So the good thing about this international registration, it allows you to stagger your costs and yet benefit from having a single registration to cover multiple countries. And so administration-wise, it also helps you to cut down some of the overheads for managing your registration.
Yeah, that's very interesting. I'm sure many business owners will find this international registration very useful, especially if they want to venture into different countries abroad. So,
yeah, Vanessa, perhaps I'll just pitch in a bit on.
Yeah, sure.
Well, this thing about filing international applications and all that, we've a lot of experience doing this. I mean, I'd just like to add, and when we assist some of our local Singapore clients with international registration via the Madrid protocol, we do support our clients if they are looking at funding assistance from the government to support that in by assisting in certain documents that the government agencies that are relevant require. And so it's been a very good process so far from what we've been doing for our clients. I think they've been quite happy with the results. I'm not sure whether, because I was looking at the chat just now while Kalyan was speaking, I'm not sure whether he might mention the one of the schemes available right now, which is the Market Readiness Assistance Program, MRA, where actually previously, pre-COVID, the amount of assistance, I think per annum, up to 20,000 Singapore dollars. But currently, the amount has gone up for funding assistance available to 30,000. So there's even more potential funding assistance available for IP clearance and protection initiatives by Singapore companies, SMEs, for instance, or even startups potentially. And so it's something that companies can consider, especially during this period when times are not great. Businesses might be facing challenging times, and every single extent of assistance on the financial side would be helpful to businesses. Yeah.
Yeah, I think that's a very important aspect to consider, especially in terms of cost. So maybe from a more strategic business point of view, so when a business, one of our attendees have asked a question as to when a business owner first ventures into a market without knowing if a product or service will be eventually successful, do you think that it is worthwhile for him to still register a trademark right from the beginning of this venture? I think this is quite a relevant question to most of our viewers. Yeah. So perhaps maybe Juan or Kaliang or Kevin, do you have anything that you would like to add with regarding to this question? Yeah.
Well, maybe I'll start. I think, well, I think it's largely, to me at least, my view is it's largely a commercial decision, to go ahead with protection or not. Whether a product or service succeeds in a particular jurisdiction, or not. Well, no one might really know. Business might, do, whether they use go into it themselves or through a business consultant. They do market surveys. and try to get as good a indication of the likelihood of success of a product or service, succeeding in a even with all that, you never really know what will happen eventually. But based on what you can gather from your your own research and any surveys that are conducted, that might give you some idea of the viability or the feasibility of incurring the cost of protection. It's always good to have the protection, and not just have it, but have it early. Preferably even before you launch a product or service in a jurisdiction. That would be the best way of going forward. So it's a commercial decision, but I think there's certain things that can help you to make a decision, that are quite on the trademark of the trademark side of things. But when it comes to the trademark side of things, before you apply protection, there's of course the the option of doing your due diligence, your searches, and then go ahead with your application.
Yeah, I think it's very important. The due diligence aspect is especially important because that's the part that people often kind of miss out when they want to file a trademark application, but it's actually very important. So I think we have come to the end of our presentation, and so thank you Kaliang, Juan, and Kevin for being with us here today to answer these questions. I thought the insights that you provided were really interesting. So hopefully we'll see you again at our next webinar as well. Yeah, so and going back to, so we have come to the end of the Q&A session as well as the webinar session. And thank you, Juan, once again for sharing your thoughts on the news classification system. I thought it was a very good presentation. And yeah, I found it really very interesting as well as the moderator. So we hope that this presentation has gave everyone more food for thought on the news classification system as well as your trademark registrations. And if you have any further questions to consult, you can always contact us at our general mail address, which I will show on the screen now. So yeah, you can always come to us. We're more than happy to take your questions. Just feel free to email us at our general mail address as shown on the screen. So yes, we are more than happy to assist you. So do come to us, and yeah. So once again, we look forward to seeing you at our future webinar sessions, which will be held every month. And I hope you all have a good day today. Thank you.